Public Protector Busisiwe Mkwhebane and President Cyril Ramaphosa are both now waiting for the outcome of a High Court challenge brought by Mkhwebane against her suspension by the President. One of the claims made in Mkhwebane's case is that the President was wrong to have suspended her because he's a conflicted person. There was also a great deal of debate in the past few days around the timeline leading up to her suspension and indeed the impeachment inquiry that's now unfolding in Parliament. Let's talk about all of these factors with Dan Mafora from the Council for the Advancement of the South African Constitution. Dan, a very good afternoon to you. Welcome to Daytime Update. So we are now 24 hours since we wrapped up basically the arguments from the different sides. When you look at the merits of the case so far, has Advocate Mkhwebane's team been able to prove that her suspension was indeed wrong?
Good afternoon, Tembekile. Thanks so much for having me. So I think one of the things that you've just said is what forms the crux of the advocate or the public protector's case, which is that the suspension by the President was a move in retaliation for her investigation of the Phala Phala scandal that is unfolding or that is underway under the acting public protector at the moment. So what she says is that her suspension came 2 days after the President, or she had sent the President a list of questions about the incident at Phala Phala, and that the President acted against her or in retaliation by suspending her. But what was interesting from yesterday's proceedings was that the DA's counsel, Advocate Stephen Butlander, set out a very interesting timeline about how the suspension came about. And we know, for example, that on the 1st of June was the first time we heard about Phala Phala. And a few days later, on the 4th of June, the ATM, which is also a litigant in this case, wrote to the public protector to say, to lay a complaint against the President. And 3 days later, on the 7th of June, the public protector sent those letters and informed the public that she was investigating. And so it does seem like, at least when we just look at the timeline from when Phala Phala is first known and when the investigation by the public protector starts, there seems to be a rush or an attempt to create a conflict on the part of the President so that he would not be able to suspend the public protector.
But Dan, that was a question that was asked, isn't it, when the announcement was made by the presidency that Advocate Mkhwebane had indeed been suspended, because weeks before that, the President had written to her requesting reasons, if I've got the timeline right here, why she should not be suspended. And it was, in essence, looming.
Absolutely. So I think the process of the suspension goes as far back as March. After the President had been informed that the committee had resumed its proceedings, he then wrote to the public protector to say, I am considering the question of suspension. You may make representations on why you should not be suspended. We know that she only made those representations in May, on May 26th, I think is the date. And so this has been a process that has been ongoing. And the question that the judges kept asking was this just a coincidence on the part of the President, or was this actually retaliation against the public protector for her investigation into Phala Phala?
You have to ask her if the presidency could not have timed it better, right? Because given the fraught nature of the relationship professionally and perhaps even personally between the two of them, Advocate Mkhwebane and the President in the last year or two, it was to be expected that should the suspension happen at the time which it did, what sort of impression would that give?
That is correct. I do think that the optics are obviously not good for the President, given that he is now the subject of an investigation that was started or initiated by the public protector or the suspended public protector. However, you will know as well that she has been arguing from the start of the process as far back as 2020, and even last year in July 2021, that it would be premature to suspend her at that stage. And so the question becomes when will be the right time, right? When will the obligation on the president be triggered, or the president's power be triggered? And that was also a central focus of the debate yesterday, to say at what stage is it appropriate then for the president to exercise this power, which is vested in him by the Constitution. And it does seem like on the public protector's version, that power would not be exercisable at all until the end of the committee process.
So as things stand, how much wiggle room does Advocate Mkhwebane have here if she's looking to save her job, which she indeed is, when you consider that she's got two things to deal with, right? She's got this court challenge, which is dealing with her suspension. She's got a committee sitting in Parliament looking at whether she has failed or is unsuitable to occupy the office of the public protector. What else can she do at this stage, given that she's lost already multiple court battles to prevent all of this going ahead?
Well, I mean, we've certainly seen ingenuity, at least on the part of her legal representatives. So one never really knows what tricks she might have up her sleeve. I mean, the one thing is that she has tried to get the president to come and testify in front of the committee process, but he has declined. So there might be a challenge there as well. But what we know for sure is either way this suspension goes, whether the court sets it aside or dismisses her application, the committee process has to come to a conclusion regardless. So the committee at the end of the day has to decide whether or not she must be removed from office, or to dismiss the motion for her removal that was tabled by the DA. And so on the face of it, there seems to be very little wiggle room, but as I say, you never know.
And is there not something to be said by the impression created that if the public protector was suspended, any sort of probe by the office into the Phala farm robbery, where the president is accused of concealing the fact that it happened, the allegations about, well, questions at least, about how much foreign currency was on the premises and whether the necessary declarations were made, and the movement allegedly of the alleged robbers across borders. Park that. Those are the allegations. The public protector's office would then look into ethics violations by the head of state, because that's within its ambit. Is there not something to be said then by the suggestion that the removal of Mkhwebane through a suspension, temporary or more long-term, would mean that that investigation does not happen, or if it does not go ahead within what the office was designed to do?
I don't think that would be something that is plausible unless you were to make very specific allegations against the acting deputy or the acting public protector.
Yes, that's what I was going to say. If there's a suggestion from Mkhwebane's legal team that she was basically removed to stop that sort of going on, that then you could argue is perhaps an insult to those who remain on duty, is it not?
100%. And the court said, or it was told, that there were no allegations of impropriety or bias or anything against the deputy public protector. So it cannot be said that the investigation would not proceed in a proper manner if all of the staff are still there and processes are still followed. And so the removal of the public protector, her suspension, is not as integral to the running of the investigation in a proper manner as she has made it out to be.
Then Mafora, always good to get your thoughts. Thank you very much for being on Daytime Update.